supplementary causes. Item number 1, pronouncement of judgment. Daily list, item number 1. Hearing, item number 3.
Lord, it is a very old matter, 2017 matter.
Yes.
The restoration, they call it restoration of the lost state. No means how same ship.
Restoration of lost state.
Lost state, they call it. Lost state, my lord.
Yes.
Here, the brief background is, my lord, I understand that the lordship may not enter into the merits of the case. Normally, we are challenging the procedure.
We have limits of our jurisdiction,
Decision-making
isn't it?
process. Exactly. Decision-making process. My lord. Now, what happened is this, my lord. This is a Norman South CM ship. Was once upon a time one of the state, like a CM ship. But during, my lord, 1876, my lord, the
1876.
yes, the successor, there was no successor in the family. Because the particular clan can occupy the chair of the king, the kingship. Now, there was no king successor, therefore the statehood ceased to exist. Now, that issue came up during the British time also.
State ceased to exist in 1876.
Yes. And thereafter, my lord, it came up in 1938.
Your petition speaks about all those background.
Yes, it is. So before I end, I invite Lord's attention to the paper.
Yes, please.
Just the brief one.
See,
So that,
see, this court is asking because sometimes lawyers make submission.
yes.
And if
Outside
we
the
go
pleadings.
take it without opening the thing, petition, and then subsequently at the passing judgment, we find that the many facts are missing in the petition. So that is why.
Right. So therefore, our duty is to confine within the pleadings. Within the pleadings.
That is the normal.
Yeah, normal. But, so it came up before the Governor General in 1937. The so-called some of the descendants of the king came forward in reclaiming for restoration of the lost state. So
Now, if that state had disappeared, then what happened? Like
My lord,
1876,
my lord, there was no more king.
yes. Then what
So
happened?
every villages live in their own way, and now after those number of decades, the so-called descendants came back and reclaimed for restoration of the kingship. Now the British government looked into the matter and said that for the last 60 years, the kingship is no more, no more. So there's no question of restoration. So the order was passed. Thereafter, my lord, the India came into being, and lordship aware, and from 1960s onward again, there was some claim by so-called descendants again. Now, from 1950s, 60s, 70s, 80s, 2019 to 2017, earlier the area was, my lord, looked after by another Mariao Semchi. Since no more Semchi, no more Semchi was there.
So you became a part of the Marios himself.
Yes, it was taken up. The administration was taken over by the neighboring Semship for the time being, and because of the desire and the wish of the community, Siddharship was established and Siddharship was continued. Now we are representing for the Siddharship and other villages, and thereafter, my lord, the matter came before the district council. District council recognized it, and even the Siddharship also, Sardar of the Siddharship also.
What is the difference between Siemship and Siddharship?
Well, the same ship is higher than the Siddharship normally.
In terms of the area
in
or terms of the status?
in terms of that, the system, customary system, as I understand, my lord, the same ship is one, next Siddharship, and then village level it comes. But Siddharship also enjoy autonomy, my lord.
So Siemship is at the top, Siddharship in the middle,
My lord.
and the village are at the
My
bottom.
lord. However, the Siddharship also enjoy degree of autonomy without any interference from any other authorities. Now, this is the brief background.
So far as the exercise of power is concerned,
Yes.
Siem and Siddhar are same. They have the same
In their
power.
own jurisdiction, they are same.
Can there be a Siddharship under a Siemship?
But normally it cannot be. It cannot be.
So Siddhar also is independent there.
My bad. Siddharship also independent.
So that way they are equal.
Right. For example, like a Sopar Siddharship, which they exist now, they are independent. They are not under the other chief. So this one also, my lord, Siddharship was recognized by district council. The issue came up and appointed the one of the petition as a chief of the Siddharship. Administration continued for a long time, and matter reached to this Guwahati High Court also, and Guwahati High Court passed an order directing the chief executive committee to relook into the matter afresh, whether restoration should be.
When it happened?
My lord, that is in 2009, 2010. I have already annexed it.
To relook the matter.
Yes, and
That
6
your
months was given.
Claim which was rejected in 1937.
Yes, so 6 months was given to the executive committee to take a fresh decision. Now the private respondent who is claiming for restoration, they never came forward for claiming. So after expiry of 6 months, they came forward to the executive committee to consider. So the executive committee, my lord, since it was already expired, my lord, it was never taken up.
The private respondents, the claim by you to restore the same chief.
No, I am for opposing the same restoration. Private respondent number 7 is for restoration. So,
Now, what is your cause of action so far as this petition is
my
concerned?
lord, subsequently, High Court has given 6 months time to the EC to consider and take a fresh decision by giving opportunity to all the parties. Now, the claimant never came forward, so matter lapsed there. After lapsing, my lord,
There means like the district council did not take any decision.
my lord, matter was because the decision for Siddharship is already there. But since the claimant has filed a writ petition,
Just a minute, Sarvesh. The court must get the facts there. Now, after High Court directed the district council to take a decision in this regard, you said the private respondent they did not.
yes, they did not appear.
Then what happened?
Then thereafter, my lord,
That made this district council not to take any decision.
my lord, there was no decision at that stage. And subsequently, my lord, after 8 months, the other side, the claimant came forward with the application requesting, and district council took up the matter calling issue notice
As
both
per
the
direction
parties.
of the High Court.
Yes. Issue notice to both the parties. Matter was kept
The
pending.
High Court said you take a decision within 6 months. The 6 months they do not take. After 8 months they come.
After 8 months.
Then file an application.
Application. And district council issue notice to all the parties for fixing for hearing, one after another. And my lord, during that time, the district council has taken a decision and brought the bill. The bill, my lord. And the bill was, my lord, passed by the district council assembly. And the bill is, my lord, is creation of a sidarship.
Taking of district council is by introducing a bill.
Introducing a bill. Introducing a bill. And the bill was sent to the governor for his assent under the 6th schedule. Now, according to me, my lord, when the district council in its assembly, in its wisdom, pass a bill, district council executive committee has no power to take contrary decision. Now, the bill was passed, referred to the governor. During pendency of the governor's assent, there was a election for the post of sidarship, So that election proceeding was challenged by the respondent number 7 again, saying that the earlier High Court decision is there to take a fresh decision. Now, before taking a fresh decision, district council is proceeding for a fresh election of the sidarship. So they obtained a stay order, and my lord, without issuing notice to our side, the Honorable High Court set aside the election process and asked the district council to take a fresh decision, to look into the matter. Now, according to me,
district council will take decisions. Initially, there was an order.
yes.
Therefore, they responded by introducing a bill.
Exactly.
Respond to it by introducing a bill.
Exactly.
In the meanwhile, before the bill could be assented by the governor,
Yes.
there is a decision to hold election for sidarship. Now that was challenged before.
That was challenged.
And the High Court quashed it.
High Court it?
Election process.
Yes, the election
they
process.
They wanted back again to reconsider means what?
It might not. That is why there was a submission on behalf of the council, standing
before
council.
One thing came to conclusion, another thing began.
Exactly. Well, so during that proceeding, the learned council appearing for the district council made a submission before the Supreme Court that we are ready to hear the matter. Only on that basis, recording that statement, High Court quashed the election proceedings without issuing notice to us, and directed the government, the district council to hear the matter. Now, according to me, executive committee cannot take a contrary decision because the appeal is there. The appeal is there.
If the direction is for to district council to take a decision, that who will take a decision?
But therefore, my humble submission would be, once, my lord, the bill is placed, it amounts to, my lord, district council taken a decision and proceed with the bill, bringing a law regarding for the sidarship. That supersedes everything. Supersedes the decision of the executive committee, either recognizing me or not recognizing the restoration. So once the bill is brought,
things are relatable. So we do not know whether these are at all relatable.
Yes. I have annexed the bill also. Now, later on, the governor has remand back the matter, returned the bill to the district council for certain remarks, and direct the district council to look into and resubmit the bill. Now, thereafter, my lord, district council has taken a decision, executive committee has taken a decision to restore the lost kingdom, which we are agree.
Restore the lost state.
The lost state, they call it lost state.
Executive committee takes a decision.
Yes.
Now this bill was with regard to what?
A bill is with regard.
What was the bill?
The bill is for the same sidarship area, same CMship area. Well, the bill was brought that this area should be established as a sidarship, not the CMship, because CMship lost its territory. Now, if we go by the history, my lord,
bill was for the purpose of legalizing this
sidarship, smaller sidarship,
which was prevailing after the state was lost.
Exactly, my lord. And if we go by the original site territory of the CMship,
now before this bill was introduced,
my lord,
the sidarship was already in existence.
Yes.
Now, how that thing was regulated at that point of time?
My lord.
How the Siddhars were appointed?
My lord, the district council used to...
the introduction of the bill and all?
District council used to appoint the sidarship.
Even without any...
Yes,
without any act?
Exactly. Because...
Or law in operation?
Yes. Because the district council has to adhere, look into the practices of the community. So not necessarily separate law need to bring and make it alive. There's few areas where even institution, the traditional institution alive without specific enactment of law also. So district council continued to appoint the sitarship, and later on they brought a bill to codify that system and make it into a statutory enactment. So for that purpose, they brought the bill. They brought the bill. Now, according to me, once the governor has a remand back the bill for reconsideration, district council executive committee need to place before the assembly of the council. Now,
What is your right before this court?
Madam,
What is your right before this court? There may be a procedural episode. Maybe you see what right you have to come and seek.
my lord, my right is, my lord, once the bill
See,
is
the bill has not conferred any right on you. Just because there's a bill, until and unless it transferred into act or rule conferring any right.
the bill
cannot
exactly.
cannot.
The
So
bill,
what right you are seeking implementation of in this petition?
well, the bill did not confer any legal rights. Shall I proceed or? or
But you will put, let's put another date.
If you agree, we can do it. You
Yes,
see,
yes.
even when court also gets involved with a hearing, would not like to be, like.
right,
He's yet to start also with all those.
next year.
We are
Yet to
getting the
start.
basic.
It's just giving.
Another, it's okay, my lord, your lordship, another 1 week or since lordship has begun, better to, my lord.
So you want it to be taken up after a week?
But
Yes, your
since the
lordship.
legislature is seeking for after a week.
Yes, yeah, I still have some other
Just on the joint request made by the parties, list after a week.
2 weeks, your lordship.
Okay,
Make it 2 weeks.
we'll come back. Okay.
Item number 4.
Nobody for the petitioner.
Mr. Senior Counsel, Mr. Paul is.
In the last occasion also there was no.
Please, Lordship. The senior counsel is on legs, Lordship, before go to Lordship.
No, he's not on legs.
It's on legs, Lordship.
So we'll have it after, at the end of the board.
End of the board, Lordship.
Yes, at the end of the board.
Item number 5.
Same counsel, Your Lordship.
Item number 6.
May it please, Your Lordship.
Yes.
Your Lordship, I had heard this matter at some length on the earlier occasion, but that was last year. So I'll have to start again. Anyway, but the issue here is quite simple. Now, the petitioner, being aggrieved by the non-reference of his claim, because this is an earlier matter,
Land acquisition.
land acquisition. So he had approached the Deputy Commissioner for reference, which was not done. My Lord, the line of the petitioner, rather the petitioner's
It was
mother,
a time-barred approach. Was it time-barred?
that is the stand. The stand of the government that your petition is barred in view of Section 18 of the Act. A lot will just see Section 18 because the whole issue revolves on Section 18.
We'll have to refresh the mind of the court, Mr. Dean. The court has forgotten everything.
Yes.
So far as the factual aspect is concerned.
But that is the simple issue because that is the stand also taken by the state government in the affidavit filed by them. We will see Section 18 of the old Act,
Yes.
1894.
Yes.
Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for the determination of the court, whether his objection be to the measurement of the land, the amount of compensation, the persons to whom it is payable, or the apportionment of the compensation among the persons interested. Now, 2 is important, my lord. The application shall state the grounds on which objection to the award is taken, provided that such application shall be made if the person making it was present or represented before the collector at the time when he made his award within 6 weeks from the date of the collector's award. In other cases, within 6 weeks of the receipt of the notice from the collector under Section 12, subsection 2, or within 6 months from the date of the collector's award, whichever period shall first expire. So under subsection 2, my lord, the upper limit is 6 months. In case I am not before the collector at the time of the award, or if 6 weeks from the date of the receipt of the notice. The contention of the state respondent is that my application is 50 days. 50 days after the award, so it is barred in terms of A and B. Now, there's another issue which has come up in this particular case. Now, in their affidavit in opposition, filed by the state respondent initially at the first instance, they have taken a categorical stand at page 16 of the affidavit number. Affidavit in opposition for and behalf of respondent number 2. Page 7. Page 7, para 16.
In behalf of respondent number 1 and 2.
2. Affidavit in opposition for and behalf of respondent number 2. This was the first affidavit filed by the state,
Is it?
DC, Deputy Commissioner.
I think before that there is an affidavit.
No, my lord, the first affidavit was filed on.
Respondent number 4. There is an affidavit by respondent number 4 also.
No, number 4. This was filed on 3rd June of 2019. Affidavit in opposition for and behalf of the respondent number 2.
That will be a second affidavit. First one was filed on 26th October 2018 by respondent number 4. Sai Singh Khongrimmai.
4 is the railway. In fact, they're not here.
The railway is not here.
Because the land has been acquired on behalf of the railways. That's why we made them a
That's why
party.
they have filed the affidavit.
Yes. Now, the important affidavit, my lord, is the one filed by the respondent number 2.
Yes. Page what you are referring to?
My lord, will come to page 7, paragraph 16. If I may read, my lord. Page 7, paragraph 16.
Yes.
That with regard to the averments made in paragraph 15 of the writ petition, the answering deponent humbly states that the petitioner's reference application was dated 27/11/2012, was submitted to this office only on 7/12/2012, after more than 7 weeks, 50 days to be precise, from the date of the final award on 17/10/2012, and therefore could not be considered as the same was not filed within the stipulated period of 6 weeks. So that is the specific stand of the government, that it is time barred. Now, my lord, initially how the government projected before this court is that the final award is 17/10/2012. Now, 17/10/2012 was the date on which the payment was made. My lord, they have referred.
They have referred here as a final award. And so
Yes, 17/10/2012. Now, my lord, will come to Annexure 1, page 11. This is what they are referring to.
Just a minute, Minister. Annexure?
Annexure 1, page 11.
Yes.
My lord, your lordship will see Annexure 1, page 11. This is a consolidated voucher for payment of 80% final payment of compensation for acquisition of land for construction of the new BG railway from Dudnoi to Mendipathar.
Yes.
Now, my lord, will come to serial number 4, number 3. My name appears at serial number 3,
Yes.
Marcella Moment. Now, your lordship will see 11,40,340.
Yes.
According to them, is payable to me. Out of which 9,12,272 was paid on 30/8/2011.
Serial number 3 is you.
Yes. Now this is 80% payment, because my lord, this acquisition was done in terms of section.
You sought reference for enhancement.
Yes. So my lord, will come. Then your lordship will go to the right, towards the right. 2,44,505 was paid on 17/10/2012.
Yes.
So the contention of the government is that this is the date of the award.
17/10/2012.
Yes.
So you have received on 17/10/2012.
Yes. There is no dispute regarding that the amount was received. The amount. Now, my lord, what is important is what is the date of the award. Section 11, Section 18, my lord, speaks about the award and the notice. If the award,
So what you are trying to contend here by
Yes.
showing this date, 17/10/2012.
which, my lord, I'll come to that, my lord. Now, subsequently, after we have filed our written submissions before this court,
You are disputing that this date of award.
yes, I'm saying that this cannot be because this is a consolidated voucher.
You file a rejoinder against it.
Yes, and I've in my rejoinder also I specifically stated that there is no award, and in the absence of the award, now the new act will come into play. But then subsequently they filed.
Then if there is no award, then how
no,
you
no.
have received this entire amount? The first initial payment on 30/8/2011.
Yes,
And your full payment on 17/10/2012.
17/10/2012. This is the receipt of the amount. I am not disputing that. Now the question here, for the purpose of reference, the award becomes very important because Section 18 speaks about the award. The date of the award, whether the award was passed in the presence of the parties before the DC, or whether the notice under Section 18 was sent to the parties, and what is the period to be reckoned, whether it's 6 weeks or 6 months. Now, subsequently, my lord, after many dates had passed, and they were given a chance to file their additional affidavit or to bring on
You
record,
want to say there was no award?
there is an award which they have subsequently stated. My lord,
No, what about your contention? You have received this amount.
Yes,
Now, what
but
basis you
I have
received?
not received the award. The award was not made known to me.
Then what made you receive this amount?
My lord,
This amount which you have received
yes,
on 2 different dates.
yes.
On what basis you have received this?
This was payment made. My lord, receiving
Payment has to be made
receiving payment doesn't mean that award is there. We are rural people there. The government has said, no, my lord,
So,
the government,
calls you to take money, you come and take money and you go.
no. we
Without
have-
verifying what for you are receiving.
We
it
have
and all.
verified, my lord. There are records to show that I have raised objections. There was a hearing held, but the copy of the award was never served upon us.
No, that is all right. That is all right. You can have a dispute with regard to the
Yes.
rate, competition of rate and all those things. Okay. But then only thing is to contend that there was no award. But to, you see, like receive money also,
Yes.
this is something seems to be very unusual for this court to understand. Now, if you say that there is no award, then why should government come and pay you money and why should you receive it?
No, but the government says that award was on 17/10.
Yes, and you
That
have
is the
received
stand
money
of the
on
government. So I
17/10.
will take this.
You have received
It
money
can
on
be
17/10.
17/10, my lord. It can be even 17/8. It makes no difference because the award was not, a copy of the award was not given to me. My lord, the law is very clear. The Supreme Court in several decisions has held that not only the notice as contemplated in the Section 18, but also a copy of the award has to be forwarded to the claimants. And that is the date from which the limitation will be reckoned. Now, not only notice is also not sufficient. In terms of Section 18, if the claimants do not receive a copy of the award, then the date to be reckoned,
So receipt of amount will be irrelevant.
yeah, irrelevant. That is irrelevant. My lord, in this regard, I've given a copy. My lord, Premji Nathu, I think it's before your lordship, that decision, 2012. I've given a copy, 2012, 5 SCC, just 250. I don't copy.
You submitted it earlier.
Citation, and we have also given a copy of the.
There is nothing. Just see, Kong, I don't think there is anything here. Nothing is there.
Now, my lord, subsequently, before we come to the judgment, the government files another additional affidavit saying that they have annexed a copy of the award also. Yeah.
Yes, where is that? Where is that?
Additional affidavit.
When was it filed?
This was filed on 23/5/2023. Now, several dates were given to the respondents to produce the records, and ultimately on 2023, 23/5/2023, additional affidavit in compliance to the order dated 21/4.
Yes, yes.
2003. Now, my lord, will come to page 2. I, Shri and so and so, resident of William Nagar, East Garo Hills, District, Meghalaya, do hereby solemnly affirm and declare on oath as follows: that I am the Deputy Commissioner of East Garo Hills District who has been arrayed as respondent number 2 in the instant writ petition pertaining to the land acquisition proceedings for construction of a new railway line from Dudnoi to Mendipatar. That actually the land compensation was paid to Marsila Momin an amount of rupees 17,70,820 as land compensation, which is reflected in the award statement dated 14th November 2011. Now, the stand of the government by way of this affidavit is, in fact, there is an award which is dated 14 November 2011.
So that way your claim is more barred.
Well, it is still not barred because this award was not.
No, if you take into consideration this date, if you accept that is the date,
if we
then
take this date, or
then your claim becomes more time. This is like
no, I'm saying that it is not barred because the award.
that is so far as your case is concerned, your contention. But then if we go by there,
If we go by this, yes, yes. If we go by this, yes.
so because it discloses a date prior to the date which was disclosed earlier in
Yes.
their affidavit.
It discloses the.
And then what happened?
So that then the government was directed by this court, you produce the records and whether you can indicate if a copy of this award or the notice as contemplated in the section 18 was sent to the petitioner. That would have been clear, Malad. If that be the case, then I would withdraw my writ petition also.
Yes.
But the government, I think, has not been able to produce that, to show that this
So
award,
yes, once that is shown, then matter is over.
matter ends.
It becomes open and shut case.
Yes. But the government has not been able to do that. Then we come to the judgment of the apex court, what it has.
There is nothing on record to show, Mr. Khan.
Except for the payment of money, the full payment on 2012.
That is the only issue to be
We'll
decided.
come back to you.
Yes. My Lord, Premji Nathu is before your Lordship, the decision. Look, subsequent to Premji Nathu case also there are many, but this is the.
This matter was heard before by the other court also.
Yes, we file a written submissions also.
So you see the note, there are notes by the,
My Lord, written submissions also have been filed.
then why you should not have landed up before this court if it was heard by you. Yes, 2012 5 SCC 250.
Yes, my Lord.
Yes. Para?
Para 12 onwards, my Lord. I've also cited this decision in my written submissions. Para 12.
Your written submission is on record.
Yes, it's on record.
We'll just see it.
Para 12, my Lord, is good. para 12.
Yes.
An analysis of the above reproduced provisions shows that by virtue of section 12(1), an award made by the collector is treated as final and conclusive evidence of the true area and value of the land and apportionment of the compensation among the persons interested. In terms of section 12(2), the collector is required to give notice of his award to the interested persons who are not present either personally or through their representatives at the time of making of the award. Section 18(1) provides for making a reference by the collector to the court for the determination of the amount of compensation, etc. Section 18(2) lays down that an application for reference shall be made within 6 weeks from the date of the collector's award if at the time of making of award the person seeking reference was present or was represented before the collector. If the person is not present nor is not represented before the collector, then the application for reference has to be made within 6 weeks of the receipt of the notice under section 12(2) or within 6 months from the date of the collector's award, whichever period shall first expire. The reason for providing 6 months from the date of the award for making an application seeking reference, where the applicant did not receive a notice under section 12(2) of the Act, while providing only 6 weeks from the date of receipt of notice under section 12(2) of the Act, for making an application for reference where the applicant has received a notice under section 12(2) of the Act is obvious. When a notice under section 12(2) of the Act is received, the landowner or persons interested is made aware of all the relevant particulars of the award, which enables him to decide whether he should seek reference or not. On the other hand, if he only comes to know that an award has been made, he would require further time to make inquiries or secure copies so that he can ascertain the relevant particulars of the award. What needs to be emphasized is that along with the notice issued under section 12(2) of the Act, the landowner who is not present or is not represented before the collector at the time of making of award should be supplied with a copy thereof so that he may effectively exercise his right under section 18(1) to seek reference to the court. In so and so, this court was called upon to decide whether the expression date of award is to be interpreted with reference to the time when the award is signed by the collector from the date the affected party comes to know about the same and held as under. Therefore, if the award made by the collector is in law no more than an offer made on behalf of the government to the owner of the property, then the making of the award as properly understood must involve the communication of the offer to the party concerned. Thus, considered, the date of the award cannot be determined solely by reference to the time when the award is signed by the collector or delivered by him in his office. It must involve the consideration of the question as to when it was known to the party concerned, either actually or constructively. If that be the true position, then the literal and mechanical construction of the words, the date of the award occurring in the relevant section would not be appropriate. There is yet another point which leads to the same conclusion. If the award is treated as an administrative decision taken by the collector in the matter of the valuation of the property sought to be acquired, it is clear that the said decision ultimately affects the rights of the owner or the property, and in that sense, like all decisions which affect persons, it is essentially fair and just that the said decision should be communicated to the said party. The knowledge of the party affected by such a decision, either actual or constructive, is an essential element which must be satisfied before the decision can be brought into force. Thus considered, the making of the award cannot consist merely in the physical act of writing the award or signing it or even filing it in the office of the collector. It must involve the communication of the said award to the party concerned either actually or constructively. If the award is pronounced in the presence of the party whose rights are affected by it, can be said to be made when pronounced. If the date for the pronouncement of the award is communicated to the party and it is accordingly pronounced on the date previously announced, the award is said to be communicated to the said party, even if the said party is not actually present on the date of its pronouncement. Similarly, if without notice of the date of its pronouncement, an award is pronounced and a party is not present, the award can be said to be made when it is communicated to the party later. The knowledge of the party affected by the award, either actual or constructive, being an essential requirement of fair play and natural justice, the expression the date of the award use in the proviso must mean the date when the award is either communicated to the party or is known by him either actually or constructively. In our opinion, therefore, it would be unreasonable to construe the words from the date of the collector's award used in the proviso to section 18 in a literal or mechanical manner. My lord, 17.
Then see that 6 months period, which has been prescribed by this section 12.
Yes.
No, sorry, section 18.
18.
18
Yes.
B.
Yes.
Section 18(2)(b). Now, when it comes to existence, so supposing if everything is dependent
On
on the date of information which the recipient received, then this becomes useless then.
Yes. 18.2 has been interpreted in such a manner by the
So that
apex
6
court.
month thing goes then.
Yes.
If we are to,
If we can satisfy,
there
like
must be some, see, it means this decision has been rendered in a situation where there was a confusion with regard to the date of award, actual date of award. Now, if we see 18(2)(b), it makes no iota of doubt that in the event when a party is not informed, that case also the date of award, 6 months time will be what. So there appears to be no confusion with regard to that.
yes, but that's the interpretation of the apex court. Malak. The interpretation of the apex
No,
court
we
is
have to
that
see the-
even 18.2, 6 months, now the interpretation of the Supreme Court will take precedence. That is 141, my lord. Article 141 is very clear. No doubt 18.2, a plain reading of 18.2 would suggest that 6 months is the uppermost period. Now Supreme Court has interpreted 18.2 to mean
Now
that
we have
6
to-
months.
Then we have to see like on what was the background in that decision, that 1961 decision, which has been referred here.
Then other decisions also have been referred. And after this decision also the Supreme Court has held that yes,
You
it
can
is the
understand when there
yes.
remains a confusion with regard to the date.
No,
of
the
award.
confusion has been created by them. Now in the first affidavit they say it's 2012. After 3 years they come with an additional affidavit. That's even perjury, my lord.
What is your actual claim? What is the actual date as per you?
1411, the additional affidavit. Actually, there was a confusion in the drafting itself. There was the date of payment of money, 17 in the first affidavit. Now she will come to the exact disbursement part.
So at least you are saying it's 1411. So if it is accepted to be correct, then he has no case. 6 months, beyond 6 months, irrespective of the fact whether he is received notice or not.
Yes, the second part, yes, Lordship is correct.
But I'm saying that in view of the interpretation of the apex court in respect of section 18.2, it is the date of knowledge and the date of communication, not only notice. Now Supreme Court has said even notice will not suffice. You have to give a copy of the award to the landowner so that he is able.
So 18(2)(b) will be rendered inoperative.
In
Second part,
yes,
by virtue of this judgment.
not inoperative, my lord, but it's widened the scope. What the apex court has done is widen the.
But this totally gives a different meaning so far as the second part of.
True, my lord. But then, as I said, 141, we are bound by what the apex court says. Now, in the other decisions also, my lord. Can you get it? Now, my lord, in Steel Authority of India versus
One
Sutni.
second. Just give 1 minute.
Yes. This is the landmark case.
Yes.
My Lord, 2009,
There is only
160,
one decision so far as your thing is concerned here, Mr.
we have given all the three. Anyway, my Lord, I'm done too.
I don't think there is. It appears there is only one decision.
3 decisions we have given, my Lord. My Lord, I think in my written submissions also we have annexed. Right?
What is the written submission? I think is 2009-16 SCC
Yes.
still Authority of India, isn't it?
Yes, still authority of versus Sutni Sangam. Here, my Lord, the Apex Court has dealt with practically all the sections of the old Act.
Yes.
And my Lord will come to paragraph 40, page 20 of the judgment.
Page 14.
Para 40, my Lord, page 20.
Para 14 is at page 14. Or
Paragraph 40.
yes, page 20. Yes.
From the scheme of the Act, as noticed hereinbefore, the mode and manner in which the amount of compensation is required to be determined is in several phases, that is, notice to the persons interested, making of an award, the period for doing so, and publication of the award itself. Section 12 of the Act provides that the award of the collector is to be final. It also provides for a duty upon the collector to issue notice of his award to such of the persons interested as are not present personally or by their representatives when the award is made. Knowledge of making and or publication of the award therefore plays an important role. For the purpose of invoking Section 18 of the Act, the person interested is required not to accept the award, that the matter may be referred to the collector for determination by the court by way of a written application, inter alia pointing out his objection with regards to the amount of compensation, person to whom it is payable, or apportionment thereof amongst the persons interested. Reference thus may be made by the collector on receipt of the application in writing, keeping in view the objections of the landowners or landholders in regard to one or all the matters as enumerated here and above. The law does not contemplate that even before an award is made, a general or vague objection can be entertained by the collector. Objection to the award, therefore, must be specific. When a reference is made, the court shall ordinarily be bound by the terms of the reference. The reference court does not have a plenary jurisdiction. It does not have any original jurisdiction to entertain an application directly from the collector or from the landholders. Once an award is made, having regard to the conclusiveness and finality attached thereto, the collector has also a statutory duty to offer payment of the awarded amount, subject, of course, to the provisions of reference. For the aforementioned purpose, Section 18 of the Act is required to be read with the provisions appended to Section 31 of the Act. The persons interested may question the correctness or legality of the award on one or the other grounds specified in Section 18 of the Act. Even for the purpose of payment of the amount of compensation and or acceptance thereto would be governed by the provisions appended to Section 31 of the Act. So here also the Apex Court has said it is knowledge of the party which is important, and the notice along with the award should be made available to the parties.
No, but then here the court has not made any discussion on 18(2)(b). I think that earlier judgment is more relevant.
Yes, more relevant. My Lord, another, that is more relevant. My Lord, just another one. This is a short judgment, my Lord. 2018-8 SCC 266.
Yes, it's there.
Paragraph 9, my lord.
Yes.
The main contention canvassed by the appellants in these civil appeals is whether an effective notice of the award was provided to the appellants herein as per the mandate of Section 12(2) of the Land Acquisition Act 1894. The learned counsel for the petitioner, Mr. So-and-so, relies on the judgment, that's what I've also, wherein the court has observed so-and-so. Now 11, my lord. That's the observation made. The learned counsel appearing on behalf of the government has not disputed the aforesaid proposition of law. Accordingly, we are of the opinion that the aforesaid observations are squarely applicable to the present case, as the notice dated 14/12/1987 was not accompanied with the award. In this case, there could not have been a valid notice of the award by letter dated 4/12/87 under subsection 2 of Section 12 of the Land Acquisition Act until the appellant received a certified copy of the award, which he did on 3/2/1988. Therefore, the reference for enhancement was accordingly not barred by limitation. Having regard to the facts and circumstances of the case, we set aside the order
Now
of the
here
Act.
12(2) comes into play. But then is it a case here the notice was issued to you?
No.
12(2).
No, notice also, award also.
So we have to decide it without referring to 12(2). Now what happens? Then how you came to know about this award, existence of award?
When they paid the money. No, we came to know about the existence only after they filed the affidavit. It was only in 2023 when they filed the affidavit, because the stand of the government is that it was in 2012, all along.
But one thing is that you have received the money, and which way it should be interpreted, that is the main thing.
My lord, my humble submission is that regardless of whether it's on 11 or 12, doesn't really matter.
Because 12(2) has nothing to do with payment and all, isn't it? Supposing it happens that it is shown that you have received the money, then 12(2) would be meaningless for you. It will be understood that you have the knowledge of the award.
Yes, as on 12
So far as the Section 12 is concerned, the purpose of issuing noting is basically to make you know about the existence of a award,
yes.
isn't it? Now, say supposing, as the case here it is, there is no 12 knowledge, but then the record shows that you have received the amount. Can't it be construed that you have the knowledge? You had the knowledge.
How can it be construed, my lord? They have to bring on record, my lord.
Then what made you file an application? On what basis you filed an application for enhancement?
We file an application after receiving the amount, the final amount.
So then if you do not know the award,
Yes.
you do not know on what basis rate was calculated.
Exactly.
Then what made you file an application? On what basis you filed the application?
Because I have a right, my lord, to claim for enhancement.
That is a different issue. Kindly say, see, this court is not questioning about your that right. Your application must have some basis, basic on which you say the rate assessed by the government is not adequate.
Yeah,
Isn't it?
that is.
Now, if at all, to your knowledge, there was no award in existence, then how do you dispute the rate?
I dispute the rate because on the amount I have received only 16 lakhs, whereas I say that my land is worth 60 lakhs. That is the basis on which I have filed my objections.
This is on the basis of the prevailing rate.
Yes.
On your own.
On the amount which I have received. I said this is not enough. I should get more. And then they come and say that the award is the date on which I received the amount. And then subsequently, that's why we come back to that issue, is whether the government can show that the notice and the award was sent to us, to me.
So, according to you, when did you come to know about the thing?
The award, man?
Yes.
On the date they filed the additional affidavit. And we have also filed a rejoinder stating so. That this award was never made
So
known
that
to
way,
me.
your application was never time barred.
Yes.
It could not have been rejected.
Could not have been time barred. That is the only the crux of the issue in this case.
Anything else?
Subject to what my friend said.
Yes, now your turn.
Lordship, I'll take your Lordship first to section 12, 12.2.
One minute, please.
Lordship, first of all, section 11 is regarding publication of the award. So how award is to be made, that is section 11. So I will. So I'm more concerned with section 12.
Section 12.
Lordship.
No, senior counsel's argument also was on section 12.
Lordship, yes. 12. I'll come to 12 too, Lordship.
Yes. Yes.
The section 12 is award of collector when to be final. We are not concerned right now with the one. We are concerned with 2, Your Lordship. Clause 2. Collector shall give immediate notice of his award to such of the persons interested as are not present personally
Or by their representatives.
or by representative when the award is made. Are not present personally, Lordship. So if we read in contrast, if they are present, then what happens? And if they are not present, then what happens? We have to answer these 2 questions. Notice is only required when you are not present.
So it means, see, the purpose of notices was there only.
Absolutely, Lordship. Notice. So if they are present, then what happens, Lordship? Now the issue involved
Do you
here
want to
is,
say, is it your submit? Of course, probably this court is moving faster than you. That since there is no notice issued, so there is a presumption that he was personally present. Do you want to say that?
no, there is not a presumption. They were present, basically. Lordship will come to that. Now, Lordship will, to answer that.
Okay, so now your contention basing on 12.2 is that since no notice was issued, they were present. Do you want to say that?
No, they were present. So the moment if they are present, notice is not required.
So that part is gone.
Yes.
So all this entire hassle goes.
Yes, so that could be one way of looking at it. No, this particular aspect, Your Lordship, none of the Supreme Court judgment have discussed this part of it.
Definitely, no, if it is there, it is not at all required.
Lordship,
Once they are present,
Lordship,
this
yes.
question of notice come as you have
I'm grateful, Lordship. Lordship is clear.
question of notice will come when he is not present,
Yes.
either personally or through his friend.
Exactly. So the moment he is present, then notice is not.
That will be implied that he has.
What Lordship has been putting this query for some time. I hope I made this point clear, Lordship.
No, the query of the court is that about the receipt of money.
Yeah, they will come
Now-
to it. Lordship will come to that. Yes, that is.
Court otherwise did not know whether he was present or not. The
Lordship,
person concerned, the
senior
petitioner was
counsel-
present or
Senior
not.
counsel is making a very interesting legal submission. But there is a grey area. First, we need to overcome if they are present and they have received the money. So whether still notice is required.
Now, on what basis you say that he is present?
Lordship will come to page annexure our affidavit, page 18, annexure A5. Page 18, Your Lordship, Annex A5.
Affidavit dated?
No, my state's affidavit, Your Lord. Counter affidavit by state at page 18.
Wait, counter affidavit. The first,
We filed one affidavit only, Your Lordship.
that is what the response number 2, which was referred to as response number 2.
Yes,
affidavit response
yes,
number
yes, Your Lordship.
Page?
Page 18, Annex A5.
Yes.
Lordship, this is from the Prakash moment to Honorable Deputy Commissioner. Lordship, date is important, 27
One
November.
is what? Who is attorney holder?
Yes.
Petitioner is and the son.
Sir.
Since he is since dead also.
Lordship, date is.
Locus standi is not an issue here.
No.
Locus standi is not an issue.
Yes. The code has to be clear.
Son. Yes, Lordship.
Okay, yes.
Lordship, date is 27 November 2012, but in bottom, Lordship, the date of receipt is 7/12/2012. Lordship, can you see when it was received? Harid, we'll just come to the main, Lordship. The main thrust, Lordship, main thrust of this letter is, this is the reference letter.
Yes.
My first argument has this, in this particular letter, there is no mention that notice under section 12 was not given to the petitioner.
But then, as you say that he is present, what is it?
I'm coming to that. First, at least we'll overcome this part.
You see, the court has to synchronize the submission. You see,
Then, Lordship, I just straight away I'll come to.
more confused by.
Lordship, then I'll come to state para 2 to answer that.
Yes. Yes, an award of so and so has been made.
Lordship, yes. So award
That is
of,
an admission.
there's an admission, and we find this figure from page 23 and 24.
Yes. Okay.
I'm sorry, Lordship. Let me answer that query. That let us give a logical conclusion to the legal issue. So this reference was made on 7/12, accepted on 7/12/2012, where there's a clear admission of this amount.
That is a clear cut admission. And then there remains nothing. If that paragraph 2 is accepted, then nothing remains to be decided in this case. Isn't it? Yes. So what else? Now we're referring to award now.
Lordship.
Just to why? For verification of the amount.
No, verification of the amount, Lordship, will just come to page 23.
No, that you were basically this court probably had interrupted you. You were saying something.
I mean, that was the second argument, but Lordship corrected me. I'll just conclude the first part of it. That by their own admission, they have received this money. Date is crucial when the reference is made.
7/12.
So for that date is crucial for the purpose of calculating.
Yes, he has received money on.
This was Annex page 16, para 16.
What was the date?
17/10/2012. The date of receipt of money is 7/12/2012. 17/10/2012. Lordship, page 11.
No, then which way that receipt of the application has a relevancy here? The court did not get your try the point. You
Para 2, paragraph 2 is in clear admission.
Yes.
We'll come to the date later on.
Okay.
So para 2 is for the.
Since you are referring to the date on which it was received.
Absolutely.
So that is
first is the admission part in para 2, and then we come to page 11.
Yes.
Lordship will come to page 11.
Yes, court has taken note of this.
Lordship will come to page 11.
Just one second. Page? Mr. Khan, please tell us the page again.
Page 11.
Page 11 of the same affidavit.
Same affidavit.
Yes, that is.
Lawrence Senior also referred to this page. Lordship, serial number 3, it's revenue received. The amount was received on first payment was on 30/8/2011,
Yes.
and second is 17/10/2012.
12.
So what was admitted in para 2 of the reference application? The source is at page 11. That means this money was paid. In other words, they were present physically.
See, paragraph
there
2
is
makes it specifically clear. You do not have to refer to page 11.
Absolutely.
It itself says
Absolutely.
that such amount was assessed,
So, Lordship.
awarded, and we have received the money under protest.
So, Lordship, so for that particular issue is concerned, which has fallen from the court, that has been answered by the own
the
reference
date.
application.
Now,
Absolutely.
if that is the main controversy.
Absolutely.
Once date goes in, then their application, there is that has to be decided.
So for that argument is concerned, I think, so, Lordship, we have.
That is what your stand is, and then what else?
And then second, Lordship, if you see the entire application, there is no way. Page, if you come back to 18,
Yes.
the second legal argument, Lordship, in page 18, Lordship, there is no way mentioned in whisper that they have never received notice under section 12 or 18. Because of not receive of notice, which is mandatory, present or no present,
There is no contention. So
that pleading is important.
Yes. So, like if both the facts taken together, paragraph 18, para 2,
That answers the first legal query.
and
Receive.
in the absence
Second legal issue is, Your Lordship, whether they have taken this plea that they have never received the notice, in spite of the fact they were present, they received the money. So no, that factual background had to be there, Lordship.
yes.
Then this court would have an opportunity to distinguish the legal principle laid down by Supreme Court on the basis of facts.
Then what made them come and receive the money on a particular date? If they did not have any information,
Lordship,
page 11, which you have referred,
Lordship,
that shows that some money was received.
80 and
Of
20%.
course.
Yes.
See, albeit they contain that was not known to them whether it's the money of the compensation or not.
But if you
For the time being, forgetting about their contention, if they at all had received some money to the office, definitely they had some information to come on certain day and to come money. Isn't it? That is implied.
implied, absolutely.
It is
correct.
not that a person will go and
No,
attend office
absolutely.
every day.
Suddenly and in the give the mercy, please come and take the money. No,
So that also shows that they had
by
prior
implied,
information.
by knowledge. And Your Lordship, the statement in para 2, the award of rupees 17 lakhs to 70,000. That also implied that this money was for the award. The word uses the award of.
Bit
Had-
slow. The court has to take.
Lordship, had it,
Pause. Give bit time. The
yeah,
court
please,
is very slow in
Lordship,
noting.
absolutely.
Yes. Now you are referring to.
Just now, Lordship said ki if they have they came to the office to receive the money without knowing what was the money. That would have been that argument could have been sustainable if in para 2 they would have not mentioned that
Who
in
received
award.
the money? Petitioner himself or the attorney?
Petitioner has.
Petitioner herself.
He was a power attorney holder, Your Lordship, so there was.
Anyway, it's all right.
That is not disputed, Lord. I don't think so. State issue. So it is not the case. The state stand is not the case that he was just going through it and the money was given, especially in light of para 2 of the application. And I was referring to 11 only for the purpose that if the court wants to further reaffirm and ascertain that how was the money paid, serial number, there are a lot of other people's. She is in serial number 3. Revenue receipt was there. In the column of 80% paid in such and such date.
Receipt was not at all disputed.
Absolutely. No, the purpose of paying the money, whether it was paid for.
See, only thing, if say supposing, if that is the contention of the petitioner, that this amount, there is no denied by them, this amount was received by them.
Absolutely.
But then if it is the contention that is not on account of the award,
Yes.
then
Lordship is
burden is on them to prove
Lordship
whether
is
it is for some other.
Lordship is correct. Absolutely correct. I'm grateful, Lordship. That point has been clarified.
Because received by them, so they will have to prove it.
Lordship is correct.
And there is no explanation to that.
No explanation to that.
Yes, anything else?
And as a cemetery lordship, in the entire application, there is no whisper that that money was not forward. That is admitted, but they have not mentioned anything about that they never got the copy of the award. That is very important.
That is, we have already noted
We
that
noted, Lordship.
this is not their case, that they have not received notice and all.
Lordship. So if that factual basis is not there in this application. Now, if that stand has not been taken in the application, there was no occasion for the court to refer the matter for reference. And there is no occasion for this court to reappreciate that particular facts. Now, this is very vital, Your Lordship, because in if both the situations are not prevalent, then on the Honorable Supreme Court judgments, there is no occasion to appreciate the Honorable Supreme Court judgment in the light of absence of this vital fact.
No, see, in absence of those facts, those judgment will be not be applicable.
Absolutely.
The ratio laid down.
I'm grateful again, Lordship. Yes.
There is no.
There is
no
a purpose
question,
of
no question.
there is no question. Had those factual background with there, maybe yes. That is my case, Lordship. There's a case of stand.
And this page 18 is not disputed,
No.
which you have referred, their application. That is, they
But
admit
then
that.
senior counsel's main thrust is
The only thing, my lord, to clear up all these issues which were argued earlier on, that's why the state government was directed to show before this court if any notice was sent or if the award was sent.
So if
But
you-
that was absent.
If your admission is there that this you were awarded this much, that is enough. It is written in clear-cut terms. That is, I don't think the court will look for more things. If something is ascertainable from the materials on record, then why should we go for looking at this? That appears to be the major hurdle for the petitioner. That part.
But then, my lord, they have to satisfy the test that whether the notice was given to us or the award.
No, you see, if you say
Merely because we have filed an objection, we have a right to file an objection.
see, notice was given or not, that becomes irrelevant once you have a knowledge of the.
Where have I stated, my lord, that I have knowledge of the award?
You have not stated.
Yes. In fact, I have filed a rejoinder.
Your
I have filed.
page 18, the part which Mr. Khan has referred just now, that gives. You see, here we can go by preponderance of probabilities. We do not need proof beyond reasonable doubt.
True.
So if that is enough, see, two things has to be taken together. One is that whatever you say in that paragraph 2 of that your application, coupled with the fact that you have received money here. Now, if you say that is not on account of any award, then it is burden is on you to explain on which account you have received this amount, on what account.
The account, my lord, the documents will show.
Government will otherwise not come. Government is not that generous and will come in lakhs of amount.
Yes,
which
yes.
you see.
No, in fact, it is the government's duty to inform. My lord, we will understand that these are all rural people. Now, that's why Section 18,
But then, you see,
Section
of course,
12, Section 12 also have been inserted to ensure that they receive a fair and equitable compensation. Now, what the government could have just done is make the award public, give a copy. That's all which is required by law. Now, how can you, my lord, how can you take these rural people? Otherwise, their land is being acquired.
no, but then it appears that you have received money.
Money I have received. I've never said I have not received.
And that's
And then in the affidavit also they say that 1712 is the award.
that is enough. And you see, money you have received.
Yes. Just by receiving money, that doesn't mean that matter ends there. No?
But then there is specific admission that you were awarded that much.
Yes.
That is what.
I'm not awarding an amount
That is good enough to show.
and
that you had
publication of
knowledge.
the award.
That is good enough to show you had knowledge. But then only one thing is that how his knowledge would be determinative to the fact that the date of this thing award. How it would help determining the date of award. This application, Mr. Khan, the question is to you.
Lordship.
Now you have referred to his application. Now there you have projected that he had the knowledge of the award. Now here we are not on the issue whether there exists at all any award or not.
Yes.
Here is that basically the computation of period
Yes.
to see whether his application was time barred or not. Now even if you assume that he had the knowledge of the award as on the date of filing of his representation, that will not make his application time barred until and unless you show that he has the knowledge with regard to the date of the award.
And the notice, madam, and also the notice.
Or we would like to contend that the receipt of amount on certain
Lordship,
date.
yes. Yeah, and Lordship, 12.2 clearly says no notice. You have to interpret 12.2 also, Lordship. 12.2 clearly it says no notice is required if they are present personally.
No,
At the
that
word
is-
no. So by
Mr. Diengdo, see, this is, I think, the issue basically is not whether you had knowledge or not. It appears that you had knowledge of the award. Since you do not dispute that you have not received any money on account of any other thing, your receipt is with regard to the award. So that is basically would be a proof to of the fact that you have the knowledge. But the only thing is the date on which you give.
Yes.
Now that become.
Now they
That
have.
is, that is what is to be determined.
Yes,
Yes.
because according to
Yes,
them it's
Lordship is correct.
17, 10, 12. The first of it says that it's 17, 10, 12. Then the 6 months period will come into play. Because unless they can show that I was present, they must be having proceedings. Now if there's a proceeding before the deputy commissioner, everybody signs. Why can't they come before this court and show that? Why can't they come before this court and show that a notice was
What's the
issued to
problem
me?
in production of the record?
Your Lordship, we have the records. That's why Lordship, I was relying on page 11. They were present and no notice is required express 12. They were present and they received the money.
But the only thing
And
is
Your Lordship, there are three links. Your Lordship. First, they were no notice is required if you are present personally. They were present when the money was passed. And by implication, that means section 12 protects the government. Then Your Lordship, when they file an application, they also admit. Now, these are three factual situations that is in favor of government. Had there been any absence of this factual situation, then yes, Lordship is correct. We have answered it, the query.
Diengdo, have you noticed
Yes.
page 11?
Yes.
There appears to be signature of other recipients also.
Yes, and on different dates,
And
not on the same
if you
date.
come to the second column, the final payment, what we say that is,
Yes, we received
you
on
find there are people who have signed it on
24 2. Yes.
2012.
Other people have.
Now,
received
so far as the confusion with regard to the date, their first affidavit and the second affidavit. Okay. Now the second affidavit says that it was somewhere in 2011, not in 2012.
Yes.
Yes.
Now this from this fact we can say yes, because most of the except you, all the recipients have signed it in February 2012. So far as
24.
page 11 is concerned,
Yes.
all got in 24/2 on the same date.
Yes. Perhaps they've got notice, madam.
That is all right.
Yes.
But then this basically would show this award was before that date.
Yeah. That's where the confusion also was created when they filed the affidavit saying that it was 1710.
So affidavit, the award is not on 17/10/2012 as has been contended
Yes,
in
by
the
them.
past.
First stand, yes, Lordship is correct. That's why we brought into the.
Your second affidavit, is there any explanation about
How?
that?
Yes.
Lordship.
That about the wrong date in
No,
past?
we have just produced, Your Lordship. There was, I think so, there was an error in drafting that should not have been there.
How can
Because
But then have you said it there is an error to this?
Lordship, no, we have not
Your
said
affidavit,
anything.
second
We just
affidavit,
produced.
no.
We have just produced.
So if your first affidavit remains there, then your both of you have not withdrawn any statement made there. So that has to be taken as a correct statement.
But Your Lordship, in first affidavit, there is no award, no documents per se next. In second, we have brought in the documents.
See, the statement
Yes.
will have primacy over the document. We'll go by what statement you make on oath before the court.
Lordship is correct. But then Lordship,
Even
whenever
if your records is something else, if you will give primacy to your statement.
Lordship is correct. But Lordship, I totally agree with the Lordship. But there was no had it been the case where different award document also was stated and then we subsequently correct, then it would have been a
You are
serious
holding
matter.
a record before you, isn't it?
Lordship, yes. The original
Is there-
record 1411. Is it?
There is nothing except for this page 11 to show the presence of the petitioner. Is there anything?
There is nothing, Lordship. We have made fair concession, Lordship. There's nothing.
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 Anyway, the court will have to determine on the basis of whatever it is.
Yes.
Anything else?
No, published. Nothing else.
When was this thing? This proceeding is of which year?
Proceeding 2000,
2009.
2009,
When this writ petition was filed?
18.
The proceedings started in 2009.
And your representation is of which date?
12, 12.
You filed this writ petition after 6 years.
No, Lord, we filed this because as per the statement itself, 27. We filed.
We have taken this time. There has been delay also.
Any this thing you have raised this plea of delay and all in your affidavit? No,
Should be, yes.
it's all right. It's all right. There is a written argument filed by Mr. Sangma.
Yes.
Stand is more or less same. But then there is no written argument from state, I think. Here.
We had, no, Shubham? No. No, I don't think so.
It's all right.
Only thing, my Lord, the written argument was filed by us prior to their filing the additional affidavit. Because when we had concluded our arguments, then they filed their additional affidavit. Anyway, the issue is still the same.
Almost same, hardly anything.
Okay, hearing concluded, judgment reserved.
Obliged.
Much obliged.
Item number 7.
Lords, this is a matter concerning Millard's declaration of the petitioner as a willful defaulter. Now, what has happened, Millards, in this matter is that the matter had gone before the NCLT, Millards.
May I please, Your Lordship? Your Lordship, the conducting counsel actually is supposed to join through VC, but he said he is in Nagaland and due to network problem, he could
Any some
not,
outstation lawyer?
Mr. Datta
he
is
is,
appearing for
from
the
Guwahati.
bank, Millards.
Is outstation lawyer?
Millards, he's from
yes.
Guwahati. But insofar as this matter is concerned, Millards, the bank's role is already done. Because what happened is, Millards, the bank had taken the company to the NCLT. The company was subsequently, Millards, dissolved, and a new management has taken over the company. So, insofar as the dues of the bank are concerned, Millards, that has already been paid off to the bank, and the NCLT has, Millards, changed the management of the company. That order we have brought on record. Subsequently, the people who have now taken over the company, Millards, they have also been made a party to these proceedings, and they are there before your lordship. So now the dispute essentially remains between, Millards, the petitioners and the new directorate of the company.
You have to explain the court about what law will be applicable, what is not. This
My lords, this is,
court will
my lords,
not
this
have any basic idea about.
my lords, this matter is entirely on the, my lords, there is a RBI circular, my lords, which is called Master Circular on Willful Default of 2013 and 2015.
What is under challenge here in this writ petition?
My lords, the petitioners were declared as willful defaulters. My lords, when a loan goes bad,
there is a provision to do that.
yes. My lords, once a loan goes bad, then my lords, there is a procedure for declaring somebody as a willful defaulter or not. Now, what I'm submitting for your lordships is the default itself has been cured by virtue of the fact, my lords, that it was a company which had taken the loan. The petitioner before your lordships were all directors of the company at some point of time. That particular loan has been repaid back to the banks. That is on record. The NCLT notes, my lords, that the dues of the
that
banks are
issue
paid
is
off.
over.
So, insofar as the bank is concerned, my lords, bank's dues are already paid.
You are no longer a defaulter.
No, my lords, that is come. The bank has filed an affidavit also saying that they have got their money.
Then what remains then?
Now the new management comes in, my lords. What happens is in NCLT, my lords, what happens is that I lose the company. The company is basically sold off. If I just put it in common parlance, well, it's sold off to some third party. Third party pays the amount, that money is given to the bank, and the third party becomes the owner of the bank, owner of this company. Basically, I am ousted completely of the company. So my humble submission before your lordships is, once the default is cleared, there's no question of anybody being a willful defaulter or not. On not even getting into the merits of the matter. I can just very quickly take
that view of the matter,
lordships.
there remains nothing to be decided.
My lords, but the notice against me remains, my lords.
Notice issued by?
The bank.
So once they say,
my lords, they've got the money, nothing remains. That's what I'm
you
saying.
said there exists on affidavit.
It is, my lords. It has come on affidavit. I can point. 26/3/2022, my lords, they have
Can't
said.
we make that a part of record and dispose of the matter?
Your Lordship, I have to seek instruction from the conducting council.
If matter is that only,
If I can just take your lordship to that affidavit.
just take note of the submission
just
advanced by
that
the senior
tomorrow,
counsel and then just look
tomorrow
for
there is one matter in.
who are the respondents here, Mr. Paul?
My lords, originally it was the Bank of India, my lords. Subsequently, my lord, under orders of this honorable court, the Jumbo Roofings is the new company which has come in, my lords. They have been made parties.
Are anyone appearing for them?
Yes, my lord.
Yes.
Appearing on behalf
What is your instruction here? What is your stand here?
I've yet to receive instructions on the same, my lord.
Oh my God. This is a case of which year? When they were implemented?
My lords, they were implemented in 2022.
Then, till now you have not received. It is almost 1.5 years. Is there nothing, if nothing remains surviving in this matter, why should we keep it pending? Have you an instruction?
Yes, my lord.
Because the bank has filed on affidavit, my lords, they say that they have received the amount of money which was due under orders of the NCLT.
So what is to be done now, Mr. Paul?
Your
You can have it after the vacations, for the since my learned friends, seniors not here, I'll not press the matter. 23/6/2022, my lords, the bank has filed an affidavit. And I'll just read, my lords, paragraph 5. They say that the deponent states that during pendency of this writ petition, the respondent bank as financial creditor had preferred a petition under section 7 of the Insolvency and Bankruptcy Code 2016 before the learned National Company Law Tribunal Guwahati bench registered as so-and-so for resolution of the debt. Thereafter, the learned NCLT Guwahati bench had admitted the petition and declared moratorium under section 14 IBC 2016, and IRP was appointed for initiation of CIRP proceedings. After formation of the committee of creditors consisting of all lenders, financial creditors, that includes the bank, the RP was authorized to publish the expression of interest from resolution applicants. Finally, after seeking a successful resolution professional on the approval of the adjudicating authority, the entire debt of the financial creditors stood satisfied on payment of a total of 34 crores as per resolution plan. And the respondent bank received its share of 4.41 crores. The personal guarantees were also discharged. So insofar
that would mean that notice would start automatically.
it has to go. It has to go.
And that is the main thing, grievance here.
My lords, no, and on merits also, my lords, on merits we had come before the lordship because the procedure was not followed. But now, in view of this, nothing survives. If there is no, my lords, default, there cannot be any willful default.
If there is no default, there cannot be any willful default.
Because the default itself has been cured, my lords. They have been paid, whatever was there.
List after 2 weeks on the request made on the way of the On behalf of the respondents, yes. Please have your instruction, madam. We'll just finish it.
What is this?
Item number 8.
What the instructions, right? Well, as your lordships have granted us time on 6/3/2024 regarding the status as operating on the ground. The instructions that I have is that the electricity is still disconnected. That has not been reconnected as yet.
So there remains a cause of action for you.
My lords.
And one is there for the other side.
Miss Clooney was appearing, I think.
Was it hard before by other court, I think? It was
In the initial stage only, my lords. After that, the matter really did not come up for
appears
final.
to be some noting made by some other judge here, maybe. What shall we do?
We can have it after 2 weeks. My lords. There's no urgency in the matter. Even my clients are not really interested in pursuing this matter any further.
Hard sponsor for the petitioner. None appears for the respondent. List after 2 weeks.
Item number 9.
Yes. Yes, madam.
Lordship, item 4. This with regard to the challenge the appeal filed by the district council. So they are saying, the district council is saying that it is filed to the tribunal, and the tribunal is the CA.
I told you people briefed me earlier.
Yes, GHDC is there.
Malaj, everybody is here. Malaj, I must confess, I am a little underprepared on this matter. I have not been briefed on this matter.
So they will take the opportunity today. They will press more. Once you say it fairly.
But I must be fair.
Rare occasion where Mr. Paul is fair.
Is it? Never say that. He's a senior counsel. After a week, Mr. After that will be enough.
Malaj.
On the request.
I'm grateful for this. Item 4 and 5 are connected matters.
From same issue, same parties.
So connected, Your Lordship. Item 5 is Govura issue and item 4 is Govura and 5 is with regard to Patai.
Anyway, same order. Parties are same here. I am the representation by the same lawyers.
Why do you say this?
I'm item number 5. I'm for private respondent number 5.
Just give your name so that he can enter. In that also we'll have after a week. Is it?
After a week.
Then why you are listed together? Is it?
No, it's not. It cannot be less.
Okay.
Malaj. This is happening regularly. If more matters are coming up, at least come over to the